Welcome again. My name is Professor Angelique Eaglewoman, Wambadia Wanwichake Washtewian. I am Sisseton Wapadan Oyate of the Lake Traverse Reservation, and I have the honor of being the director of the Native American Law and Sovereignty Institute here at Mitchell-Hamlin School of Law. I'm presenting on my most recent law review article, and I'm going to bring in a lot of context as well. So I assume all levels of knowledge and expertise in this area of law. Some of it may seem very basic, some of it may seem very complex. So just a lot of material I'm going to go over today to give you really a deeper understanding of why I am making this strong statement that we need to always capitalize the word tribal and tribal nations when we see that word. So here we go. The dignity and sovereignty of tribal nations, capital letters. So here's an overview of the topics that I want to go over today. I want to talk about the tribal nations that were here since time immemorial. I want to talk about tribal nation-U.S. relationships as treaty partners, eras of U.S. Indian policy, political status and tribal membership, and then decolonizing citation and the English language. Finally, I want to remind us we are all treaty people. So when I talk about the basics on proper understanding of tribal nations, one of the things that I want us to know is that tribal nations existed, and we use this as a legal term, since time immemorial. That means prior to human memory, dating back before people have oral stories or traditions that go back in time. So you notice that in many publications in codified U.S. law is the term Indian. This is a misnomer. We know this is a misnomer. This came from a word that's adopted by back in the eras of European travels around the world, and we'll talk a little bit more about that. This idea of a fleet of boats trying to make it to India and misnaming everyone in the Western Hemisphere. This word is then picked up by Great Britain. Great Britain is the parent of what then becomes the United States and Canada. So I often talk about the United States and Canada siblings from Great Britain. So it's the wrong word, but the term Indian has been taught to our ancestors as the word for our people in the English language. And so we still have it, it's still codified. We use the term Native American for the Native American Law and Sovereignty Institute. I use it in my courses and in my writings. And one of the reasons I do that is it's an academic term, but it's also more inclusive. When we talk about tribal nations, we talk about both those in what we call the lower 48 and the Alaska Native villages. So of the tribal nations, the 574 federally recognized, 228 are Alaska Native village tribal governments. So it's a more inclusive term. Internationally, the term used is indigenous peoples. And peoples, the reason we have an S is because that relates to the United Nations Charter. The UN Charter says that peoples have self-determination. And so when we talk about indigenous peoples, we want to emphasize self-determination. As Native people, we always identify with our specific tribal nations, and it is standard practice for us to always identify ourselves by the people that we are from. And you heard that today with our students. Another thing I want to emphasize as we get started is that we are tribal citizens. We are part of our tribal governments, and that is part of our tribal sovereignty, our tribal membership. That is a political status. And I'm going to talk about how that's been blurred in many publications, in many U.S. Supreme Court decisions, and in mainstream understanding of who tribal citizens, tribal members are, what it means to be American Indian or Alaska Native. So we have a political status because we come from tribal nations that pre-existed the United States. So I want us to be very clear about that. Tribal governments determine their membership and citizenship, and often we see government forms asking people to self-identify, and that also can blur things with who are tribal members. There can be confusion. We have the U.S. government not being consistent as well. We have the U.S. Department of Education, the U.S. Census Bureau, and we also deal with the U.S. Department of Interior, which is very much has a definition of who tribes are and tribal members. So we have conflicts within the federal government, and then this can blur over into state government and organizations. When we talk about this land and this, has become known as North America, there are many traditions that talk about Turtle Island, that this area, this North America, actually is in relationship to us as a living being. And that's also part of how we view Mother Earth. So I give you this rendition of how that turtle may look when we think about it. Another lens I use when I talk about our relationship with the United States and Europeans and Great Britain and all that history is economics and trade relations. So this is a map of estimated trade routes. We had trade routes that went from the very tip of what we now call Canada to the very bottom of what we now call South America. And if you look at this, you'll get a sense that all of the U.S. major highways are built on our trade routes. So this idea, this misnomer, this myth that there was a pioneer out there whacking weeds to get from one place to another is completely wrong. Our roads were used. We had people that traveled long distances and engaged in trade and commerce. And so there's this whole history from the 1500s really to the 1700s that is not developed well about the intellectual knowledge, the economic knowledge, the cultural knowledge, the social knowledge, the governmental knowledge of who we are as tribal nations and tribal peoples, and how all of this has been suppressed. And so I'm glad you're here today and we can talk about these things. So going back to this article, the article is capitalization of tribes, tribal nations, and the word tribal if it's referring to anything governmental. And this came out June 26, 2023. And I talk about something that we're more familiar with in contemporary times, misinformation, right? Disinformation. We hear a lot about that with social media and the internet. Well, one of the things I posit is that that's what's happened with tribal nations in written words, in spoken words for hundreds of years. It's misinformation. And I talk about this comes from the base motives of greed and genocide. The colonizing language of dehumanization was distributed as disinformation to build U.S. political momentum for land theft, massacres, and other atrocities committed against tribal nations and tribal peoples. Because when you dehumanize people, then it can lead to public sentiment against those people and atrocities can happen. Tribal nations, or governments, are nationalities, and therefore, as I say in this article, should be capitalized like all other nations, nationalities. Also, when we think about talking about the relationship between tribal nations and the United States, if one side's capitalized as a government and the other side is not, that's obviously just a visual imbalance of power. And I'm here to say that we need to stop doing this. We need to stop dehumanizing and undermining tribal sovereignty. When we talk about our sister tribal nations in what is now Canada, we have a capitalized term, and I think that's wonderful, and that should be there, and that should be known. First Nations, capitalized. And as we go through the resources I'm going to talk about today, we're going to see that there's a recognition First Nations is capitalized, but at the same time, we do not see the same in the United States for tribal nations. I say that the lack of capitalization in the United States for the terms tribal nations who have engaged in political diplomacy with the federal government is a remnant of the colonizing disinformation from a bygone era. I also throw out there rhetorically, when you hear the words American Indian, how is there a mental difference in using that term than using the word native, right? It's a further disconnection of the original people from these lands, to our home continent, to our home place. When you use the word American, now you've used an external label, and Indian has nothing to do with us. So we often use the word native, meaning for here. All right. So I ask, which one disconnects tribal peoples from this continent? As we start talking about interaction with Europeans, what we have is this history in Europe of Christianity and Christian doctrine mixing with law. We have these orders that came out of the Catholic Pope called papal bulls. And through these papal bulls, it's solidified in a concept called the doctrine of discovery. The one that applies to North America is Pope Alexander VI, Bull Inter Caetera, on May 4th, 1493. And the idea was that Europeans, Christians, only respected the land rights and government of other European Christians. Anyone who was non-Christian would be subject to Christian authorities, officials, envoys, ambassadors, and have what was thought of at that time by Europeans as universal rights to subjugate native peoples in their homelands and refer to them as pagans or infidels. Monopolized trade was seen as a universal right and convert them to Christianity. And if tribal people, native people, resisted any of those three things, they were then subject to, according to papal bulls, a just Christian war. Remember, we have language barriers at this time. We obviously are not having legal discussions back and forth, understanding where such doctrines are coming from. As these concepts are being enforced, first through what we now call Central America, but then up into North America, we see British kings adopting this same concept and language. And in the 1600s, they start chartering trading companies to be in North America. And so one that's still active is the Hudson Bay Trading Company. But there were a whole series of them. Virginia, Chesapeake Bay, all different kinds. And within those charters, they used the language of the papal bulls, that they had the right to monopolize trade, to convert to Christianity, and assert career title over anyone that was non-Christian. The U.S. in a U.S. Supreme Court case, Johnson versus McIntosh, in 1823, asserted it has successor status. In other words, it received everything that Great Britain did and all of its rights through the Treaty of Paris. And therefore, the U.S. asserts its claim to the doctrine of discovery. I often ask my students, is the United States a European nation? Are we in Europe? No. How in the world does the United States get to claim a European-based doctrine? So we have a problem here with the way in which this Christian legal doctrine, which divides up who has legitimate title, who has property, who has the right to govern, and who has the right to determine who they're in economic partnership with, based on these really discriminatory views of Native people and this colonization framework. I will say on March 20, 2023, the Vatican rejected the doctrine of discovery as used to justify colonization. I will say the Vatican did not take any responsibility for establishing the doctrine or its impact. But that is a statement, and that is a step, and that is something that's been called for decades. So that did happen. That does not change that the U.S. Supreme Court continues to uphold the doctrine of discovery through Johnson versus McIntosh. This is still good law in the United States, and under this case, tribal nations hold title in occupancy status with superior title in the United States. So, we still have that. It is still taught in every first-year property law class in the United States. And I think that's a problem. I think that's problematic. That's a colonization doctrine. And even though, I will say this, even though changing very old concepts upends things and can change the way that we do things and rewrite all the books, we still do it because it's necessary and it's right. And these are human rights we're talking about. So when we talk about treaty relationships, this is the earliest fundamental relationship between the British Crown, the United States, and tribal nation. And I always want to start with tribal nation views. What were the tribal nation views in terms of entering into treaties with Great Britain or the United States? First, again, tribal nations existed since time immemorial. And what that means is there's been a long history of tribal nations engaging in alliances and confederacies. We even talk about having treaties with the Hoof Nation, with the Fish. We have a long history of relationship, agreements, reciprocal obligations. These are not new concepts to us. So in entering into these with other groups of people, we saw it as relationship building. And you'll see that we came from and still come from a kinship view. We see people as our relatives. And that's what you see when you look at the talks that are given, what is written down. You know, we have to interrogate sometimes what is written down, but what is written down on behalf of tribal leaders engaging in treaty negotiation, we see relative terms because that's our worldview. We have a long history of agreements. We also have a long history of sacred promises. When tribal leadership entered into treaty agreements, they did so with our concepts of looking forward. Many of us talk about looking forward 7 generations. And this idea that we will make these agreements with you. We will allow you to be our permanent neighbors and settle near us. And we will tell our children, our grandchildren, our great-grandchildren, and so on about these obligations. And we expect the same from you. That's what our sacred promises were. They were entered into with ceremony. They were entered into with the idea that they would be frequently renewed as well. We continue to do that. We continue to come back into council, into consultation, into joining together to renew our commitments, just like every other treaty partner does. We're just hearing about, the United States and China meeting. You continue to renew the relationship. That's the expectation. We're also a people of symbol. And so we take symbols and memorialize the agreement. We use symbols to talk about very complicated concepts so that we have the whole thing embedded in that symbol, and we pull it out and we can talk through it and explain what that meant to us. And so pulling that into the larger law review article, language and the visual representation are symbols as well. And to me, that's important for those capital letters as symbols. We have oral histories that contain the meaning of treaties. We extended it to future generations. The tribal leaders were very astute in wanting to protect our tribal lifeways, our resources. And when we talk about agreeing to stay on certain parts of our territory or moving to a different territory, often our tribal leadership had the foresight to say, and we will continue off reservation, hunting, fishing, and I like the word harvesting over gathering because we stewarded resources, off reservation perpetually, in perpetuity, never ending, because we expect to never end. We expect our tribal nations, our tribal people, to always have and use these resources. There's no end date to those. We did not sell land to others. We allowed settlement by us. We could not be given land by newcomers because we owned it, right? But these concepts were twisted with the doctrine of discovery and the U.S. Supreme Court case Johnson versus McIntosh. On the British-U.S. side, it was expedient to enter into treaties to acquire means for settlement and industry. Treaties were written in the United States in the English language with legal terms. Courts now are supposed to adopt interpretive terms. We call them the canons of construction to resolve ambiguities in favor of Indians, to interpret terms of treaties as the Indians would have understood them, those kinds of things. But again, it's still largely non-native judges making those interpretations. The majority of U.S. treaties promise perpetual peace and friendship. Treaties were necessary to establish legal title to lands, and land seizures were possible without entering into treaties. And we say that the treaties have all been fully or partially abrogated. So this may sound a little cynical, but this is one thing that, in my view, has happened. Where treaties have been abrogated, so we'll talk about U.S. Indian era policies, one of the major ones is the allotment policy, coming in and dividing up our land base into small allotments and then taking the surplus from us. That abrogates every treaty that reserved a homeland. However, we also see the U.S. Supreme Court continuing to uphold hunting and fishing and gathering or harvesting rights from those same treaties. And so, again, this may sound cynical. I see that as the U.S. Supreme Court never fully abrogating a treaty to ensure that land title by the United States is secure. So part of the treaty is upheld to make sure the title is good for the United States. When we talk about the formation of the United States, we talk about the U.S. Constitution. And where are tribal relations in the U.S. Constitution? Well, the U.S. Congress power in Article 1, Section 8, Clause 3 is what we call the Indian Commerce Clause, to regulate commerce with foreign nations and among the several states and with the Indian tribes. There's also the treaty power in the U.S. presidential power, Article 2, Section 2, and that involves the Senate to ratify treaties. And then my favorite part of the Constitution, I know my students know this, is the Supremacy Clause, Article 6, the Constitution and laws of the United States, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby anything in the constitutional laws of any state to the contrary notwithstanding. Is a recognition of tribal nations, separate entities, their own governance, engaging in commerce with the United States and treaties. Tribal nations in the early Minnesota formation. So, for a lot of tribal nations, tribes were engaging with U.S. federal authorities and entering into treaties, and as part of those treaty negotiations, the United States then organizes the surplus or the other lands as a territory, and then that territory organizes to join the United States as in the Union. And then we have often seen those state governments then want to override tribal nations' sovereignty, governance, and territory, unfortunately. So there were approximately 10 treaties entered into by the United States with tribal nations in the region that became Minnesota up until 1871. I do want to point out there is a questionable legal basis for the purchase of land for Fort Snelling. You can read more about that at the Minnesota Historical Society, but there is a problem there. On the tribal side, again, we had terms for permanent neighbors, kinship, trade relations. On the U.S. side, there were terms for land purchases, cessions, purpose of forming states, control of resources, waterways, and expansion of governmental authority. Minnesota joins the Union May 11, 1858, and state leaders immediately pushed for more land ownership and to dispossess the tribal nations who had lived here since time immemorial. One of the saddest, darkest parts of the history in this region is the U.S.-Dakota War of 1862, where the Dakota people were subject to starvation conditions, late treaty rations, heavy-handed coercion on land cessions, and it divided the Dakota people on how to deal with this situation. So some of the Dakota people felt that we had to engage in war and stand up for the territory that we had left. There's a whole history there. I have a law review article on it. If you want to read more, there are books about it. But after this war, the largest mass execution in the history of the United States was held in Mankato, Minnesota on December 26, 1862, and the Dakota people were scattered. Some remained in Minnesota, thankfully. 4 fairly recognized tribes are still here. The Dakota peoples are now throughout Canada, North and South Dakota, what became Montana and Nebraska. Here's a map of Minnesota land cession treaties and the 11 tribal nations that are in Minnesota. What we are now surrounded by the state of Minnesota. And you heard about that in our land acknowledgement. And I really want to applaud the efforts for Indigenous education for all and for starting to build the public education system's knowledge of the tribal governments here in Minnesota. So we have the 4 Dakota, also known as Sioux, tribal nations, and the 7 Chippewa, Anishinaabe, Ojibwe. All 11 operate tribal court systems. And we have a website for the Minnesota American Indian Bar Association that will give you more information there. So we continue on. One of the ways that we try to organize the relationship between tribal nations in the U.S. is by talking about eras of U.S. Indian policy. So again, this is on the U.S. side. And we talk about a pendulum swing or a perpetual wave machine. And this idea of U.S. officials going back and forth between recognizing our government-to-government relationship and completely trying to disregard tribal nation status. So we start with the treaty era from 1778 to the mid-1800s. So there is that recognition. Only sovereigns entered into treaties. But then we have 2 overlapping eras. We have the removal era where those tribes that are east of the Appalachian Mountains first and then east of the Mississippi River next are getting removed, coerced out of their homelands with military force, military marches. At the same time, we have the reservation era going on where we do have recognition that on our reservations we have tribal laws and our people are part of our governance and our tribal territories. The pendulum swings in the late 1800s to one of the most devastating eras of U.S. policy ever. And it's hard to overestimate the intergenerational trauma and injury that came from this era, the assimilation and allotment era, where our tribal land bases were broken up into small parcels. Tribal governments have never been compensated for that, and the lands were then divided out into individual heads of households depending upon the local Indian agents. When I say Indian agent, that is the U.S. Indian agent that is assigned over a reservation. It had a lot of control. We also see it in this time period a way to coerce tribal leaders into agreeing to allotment or any other decision was to take our children. And so we have the beginning of the Indian boarding schools, which were run in military and also religious organization methods with every type of abuse you can think of. When we talk about our children in the Dakota language, we use the term wakanja, something sacred growing. Our children were and are beloved. And so you'll see old writings where you have people of Christian faith writing about how tribal peoples spare the rod. They don't hit their children. They don't do these sort of punitive things, and that's seen as not raising them correctly. Whereas if you look at our traditions, there was a very purposeful softness and gentleness to raising children. So this was a huge difference for us in the way to treat human beings, and for at least 4 generations to be raised in these inhumane conditions without family, without language, without their culture, and to be really verbally, emotionally, and sexually abused. So that era, again, we're still trying to recover from. It still impacts us today. There were reports that came out that eventually led to a change in policy. The next policy era swings back to understanding tribal governments as governments, and we call this the Indian self-government era. And this is where the Bureau of Indian Affairs rolls out boilerplate tribal constitutions. And they're not what you would see in the U.S. Constitution. These are bylaws. These are the types of things that you saw for organizations like the Lions Club, things like the Masons, and they were just inserted tribal government names, and then over time, one thing that Native people often do is if they don't agree with a policy, they withdraw. So over time, the U.S. Indian agent would call a vote on tribal constitutions, and people would not come out to vote. And so then they flipped it. You must come and vote not to accept the Constitution, otherwise you adopted it. So that doesn't sound like something the United States democracy is supposed to do, but that did happen during that time period. As tribal governments used the tribal constitutions and had more decision-making authority in their governments, we see a backlash. And the next era is termination of tribal governmental status. This era is where the United States Congress, through House Resolution number 108, has a list of over 110 tribal nations, and they just removed federal recognition. And there was other lists that were planned out as well. Through large organizing of tribal leadership, we have the National Congress of American Indians established, many regional tribal chair people associations, and a pushback and lobbying effort to stop this era. Even during the termination era, the U.S. Supreme Court is still in its decision saying the treaties are not terminated. The treaties still go on. So the treaties are enduring, is my point there. And then the policy swing that we're now in We call it Indian self-determination era. And I put Indian on the front of that because it's not full self-determination. We still have a lot of federal government control over many of the decision-making aspects for tribal nations. But that is our current era from the late 1960s to the present. And we have seen strides forward in better relationships in many ways with the United States from time to time in this era. So that's how we try to organize it. And I want you to think about being a tribal leader during this time period or knowing this history, and how easy is it now for you to trust a government that can simply change completely its position in terms of your relationship. So there's always a need to rebuild trust and for these relationships to mean something ongoing, long-term. We even see this recently between two different presidential administrations and how things can change between those two, where we thought we had a firm understanding of reservation status or trust, land in a trust status. And we can see a U.S. president changing that. In terms of tribal jurisdiction, there are 3 sovereigns. That's how we talk about it in my classes, in our certificate in the United States. There's a federal jurisdiction, state jurisdictions, and tribal nation jurisdictions. We do have and look at some U.S. case law that talk about tribal nations' reserve powers. Any powers not surrendered or limited in a treaty remain as part of the tribe's powers of self-government. That is U.S. versus Winans. Remember that case from 1905. Also, the 1934 Indian Reorganization Act provided an option for federally recognized tribes, Alaska Native villages, to adopt tribal constitutions. There was companion legislation for Oklahoma, the Oklahoma Indian Welfare Act. And again, when we talk about tribal membership and citizenship, this is another area that is often not understood. Tribal nations existed before the United States. U.S. Indian agents during that allotment policy developed what we call the tribal rolls as lists, and there could be all number of reasons people were left off those rolls. The rolls were used not only for allotment policy, but for distributing rations, which is food, that were owed to tribes as payments. The rolls were brought into the U.S. tribal constitutions. Remember, the BIA wrote them. The Bureau of Indian Affairs within the Department of Interior wrote those tribal constitutions. And they included this concept of blood quantum. This is not a concept that tribal people ever use, blood quantum. This actually comes from the European monarchy and the idea of blue bloods and tracing paternity or maternal line in terms of European ideas of monarchy and nobility. So that was brought over here and placed on tribal people to minimize our connection to who we are as a people. So I often use this example. If you have one person that is known, their whole ancestry comes from Dakota, and they marry another person who is known, their whole ancestry is Navajo, under the way the United States looks at tribal membership, if those two people marry and have a child, the child would enroll in only one tribe, and then they would be half. If that child then marries into another tribe, their child would enroll, if they enrolled Dakota and it wasn't a Dakota person, now that child is a quarter. And that's the cutoff, 3 generations often for many of the blood quantum calculations. And that is something that tribal nations have to address. The U.S. Supreme Court has had 2 decisions that touch on this in a way. Versus Morton versus Mancari in 1974, and it provided that tribal nations have a political relationship with the United States. This case is based on an Indian preference and employment and promotion provision within the Bureau of Indian Affairs, and it was subject to an attack under the the Due Process Clause of the Fifth Amendment for non-Indians working within the BIA. They challenged it, and they said that it was impermissible for particular preference within employment in a U.S. federal agency. And the United States Supreme Court held this is a unique relationship between tribal nations in the United States, and therefore a political classification rationally tied to a non-racial goal, and upheld it for that political status. Second, in 1978, we have the Santa Clara Pueblo versus Martinez decision, where we have a tribal member bringing a challenge to the tribal membership law into the federal courts. And there, the U.S. Supreme Court held that there was no action available within federal courts to challenge tribal membership rules. The act that was mentioned was the Indian Civil Rights Act, which only provides habeas relief in criminal proceedings. And so there was a barrier for the federal courts as a separate external court system to decide on a matter internal within the exclusive jurisdiction of tribal nations on tribal membership. Many people have family stories and lore and ancestry handed down. It's like a DNA test to claim ancestry. However, this does not confer legal status or tribal affiliation. A person must contact the Tribal Nations Enrollment Office for details on how to become a tribal member. I don't think that's well understood either, or the reason why it's so important for the political status for us to continue on as tribal nation governments. And people tend to look at things in terms of racial classification, which is not our status. We talk about political status and journalistic integrity. There hasn't been a lot. I think maybe there's a lot of misinformation. Journalists don't understand this. And so the reporting isn't accurate on the legal status of who is mentioned. No entity can override tribal sovereignty in determining who is an American Indian or Alaskan Native. So we find there can be inaccurate reporting of a person is linked to a tribe without verification. That would be considered misinformation. We have a huge anti-tribal movement against tribal nations that's existed since the United States was formed. Recently, there was a failed attempt in a case brought under the Indian Child Welfare Act to recast American Indian and Alaska Native children as part of a racial classification and undermine the ability of the U.S. Congress to pass the Indian Child Welfare Act, which has in place a transfer provision from state court to tribal court, any out-of-home placement of an American Indian or Alaska Native child. And if the case remains in state court, then the state court is to follow placement preferences that start with the child's extended family and then other members of the tribe's child and other Indian families. Holland versus Brackeen, the U.S. Supreme Court rejected that challenge and held that Congress did have the power, and it was embedded in the Indian Commerce Clause, the Treaty Clause of the U.S. Constitution, the Supremacy Clause, and then talked about the trust relationship between tribal nations and the United States as upholding Holland versus Brackeen and the ability of the Congress to pass the Indian Child Welfare Act, and drew upon the pre-constitutional powers of the United States as necessary part of its sovereignty to enter into relations with the tribal nations. So that was June 15, 2023. Again, we see those that would like to exploit our lands and our resources and override tribal sovereignty. Law firms helped bring that challenge. So we see media overclaiming American Indian status for employment in academia, scholarships, admissions, etc. I give you some real recent examples here. This undermines tribal sovereignty, determination of their own citizens. This is exclusively for tribal nations to do. Verification is necessary due to widespread fraudulent identification to reap educational, employment, scholarship, publicity, and other benefits. All right. As I'm talking about journalism and as I'm talking about media and as I'm talking about misinformation, I want to move more closely now to the article. And one of the first things that I talk about is the AP style book. And I'm going to read part of this slide to you. When we look at the AP style book, this is the online version, and you do a search for the word tribes, tribe, here's what I got when I put this article together. Tribe refers to a sovereign political entity, community sharing a common ancestry, culture, or language, and a social group of linked families who may be part of an ethnic group. Capitalize the word tribe when part of a formal name of sovereign political entities or communities sharing a common ancestry, culture, or language. Identify tribes by the political identity specified by the tribe, nation, or community. The Apache tribe of Oklahoma, the Cherokee Nation. The term ethnic group is preferred when referring to ethnicity or ethnic violence. I was shocked when I saw that. And it was an impetus to write this article. There's so much to unpack there, and so that's what I do in the article. I try to unpack all of this as these lines are meant to identify this word tribe. So we do have acknowledgement that there is a sovereign political entity, but then immediately this definition turns towards ethnicity. There's no rationale provided why the term tribe is not capitalized. The list implies that a community is equal to a tribe or a tribal nation. This is not politically accurate in U.S. law. The last sentence seems at best out of place, and it's disturbing. The linking in the reader's mind to specific tribal nations and ethnicity or ethnic violence harkens to the disinformation of the colonial era. With the history of with genocidal colonial violence aimed against tribal nations as a defining policy to establish and expand the United States, this last sentence recalls this historical practice to impress upon the reader's mind a connection between tribe, particularly identified tribal nations, the Apache tribe of Oklahoma and the Cherokee Nation, and ethnic violence. Further, rather than include the understanding of tribal derived from the sovereignty and political status of tribal nations, the AP Style Book relies primarily on Native American under its race-related coverage categorization. So the Style Book requires that the use of the term Native or natives as a noun may only occur on second usage after the use of the term Native American. Why? This external decision-making on the proper use of a noun for the native peoples of tribal nations in the United States does not reflect common uses by natives themselves. So while the AP Style Book correctly notes the following for the tribal governments in Canada, First Nation is a preferred term for tribes in Canada, but note the small letter T in tribes, referring to the same political entities capitalized as First Nation. It should be noted that the Canadian-US political border cuts across tribal nations. And so we have people on both sides of the border that are the same people. But on one side you get a capitalized First Nation, on the other side you get a lowercase tribal nation. Absolutely ridiculous in the United States. Many of us are the same people, we have the same language, participate in the same ceremonies, practice the same traditional legal principles. And as I told you, I was dean of a law school in Canada. So there's no reason why this convention should be the way it is in the United States. I also take issue with the Chicago Manual of Style Online, Manual of Style Online, and I find this a derogation of tribal nations. So I used a searchable index and I put in tribe, tribal nation, nothing came up. Then I used Native American and I got 8.38, ethnic and national groups and associated adjectives. Names of ethnic and national groups are capitalized. Adjectives associated with these names are also capitalized. For hyphenation or its absence, see 8.39. And the example is given is the Hopi, a Hopi, Hopi customs, Inuit, Inuit sculpture, Native Americans, Native American poetry. So this doesn't list the Hopi tribe, and it doesn't say capital the Hopi. The first term in the list should include the formal name of the tribal nation. This is a political entity. This is a federally recognized tribal nation. The second term should be followed with person, as this is standard when referring to a person of a tribal nation or any other human. For example, it would not be common to refer to a white or a French. and therefore is not properly referred to a Hopi as providing this manual on style for writers. Extrapolating from this entry, the Chicago Manual of Style Online fails to properly acknowledge the political status of tribal nations, perpetuates notions of colonization that hold tribal governments to a group status, and dehumanizes persons who are citizens of tribal nations. So we have the absence of political status in the Chicago Manual of Style Online. In the last paragraph on this same page, the Chicago Manual of Style Online does not include any reference to the political status of tribal nations or specific tribal nations, rather focuses on the terms American Indians and Native Americans. And this is what it provides. Many among those who trace their roots to the Aboriginal peoples of the Americas prefer American Indians to Native Americans, and in certain historical works, Indians may be more appropriate. Canadians often speak of First Peoples and of First Nations when not referring to specific groups by name. There's a lot embedded there too. Who gets to determine what we prefer? And further, the tribal nations of Canada are appropriately referred to as First Peoples or First Nations. However, in the same sentence, they are relegated to the status of groups rather than nations or political entities. Why is this so important to me? Why is this so important at all? These are the style guides for media in the United States. These are the style guides for high schools, for colleges, for writing a paper about, for basic education in this United States. And this is what we have. The AP Style Book and the Chicago Manual of Style Online both include the capitalized term First Nations for the tribes in Canada and fail to include the capitalized terms tribal nations or tribes. The AP Style Book also does a grave disservice by linking the word to ethnicity and ethnic violence when using the term tribe. The Chicago Manual of Style Online fails to include tribe as a defined word and derogates their political status by referring to Native American groups. So these guidebooks for writers in the United States recall the disinformation and dehumanization tribal nations faced for centuries in the United States mainstream media. This disinformation stems from U.S. officials and elites who implemented and encouraged colonizing policies of genocide and violence to engage in land theft. Then there's the Blue Book of Legal Citation. In the index of the 21st edition of the Blue Book, there's no listing of tribe, tribal nations, or First Nations. There are two listings that I found: Navajo Nation and Oklahoma Native Americans. There are over 570 tribal nations in the U.S., and each of these tribal nations has a set of tribal laws with over 300 tribal courts. The Blue Book does not follow the citation format of the Navajo Nation for Navajo law or Navajo court decisions, right? So it substitutes what the tribal nation uses itself for its citation to its laws. To provide proper respect to tribal nations, the Blue Book should adopt the same form of citation the tribal nation utilizes. An added benefit to following the lead of the tribal nation referencing proper legal citation for tribal law sources is uniformity in legal citation. Isn't that the name of the Blue Book? Uniform Guide. Internally and externally for tribal laws. The lack of attention, index entries, or acknowledgement of tribal nations in the United States style and citation guides follows a pattern of colonization and lack of respect for tribal sovereignty and legal systems. The Blue Book perpetuates the downgrading of tribal sovereignty by not including an index or a subject listing for tribal nations with specific tribal nations set forth. And again, capitalization. Blue Book Rule 8C1 on capitalization provides nouns that identify specific persons, official groups, government offices, or government bodies should be capitalized. They provide a list like Commonwealth. This should also include tribal nations and the use of tribal when referring to tribal governments in the United States. For legal educators, law students, and lawyers in the field of Native American law, the Blue Book perpetuates ignorance of tribal nations, tribal courts, and tribal law through omission and inaccurate information. And it's not like tribal nations suddenly came into being. They pre-existed the United States of America. It is high time this is rectified. In my article, I don't stop there. I go on and I talk about some of the common phrases I have had the bad fortune of experiencing in my life as a Native person. And I categorize phrases applying racist characteristics. For example, and I'm sorry to have to say these out loud, but I will, behaving like a bunch of wild Indians. We see in the U.S. Supreme Court decision Johnson versus McIntosh terms such as heathens, warlike tribes of Indians, and fierce savages, all similar to the meaning of wild in the above phrase. These derogatory terms were used as the court held that the European religious doctrine of discovery was claimed by the United States to gain superior title of all tribal nation lands, and thereby devaluing tribal land rights to an occupancy title. Turning to the second phrase, Native Americans in defending their homelands have been characterized as warlike and on the warpath. Tribal nations entered into diplomatic relationships with the United States and were betrayed when the United States failed to adhere to legal obligations formally agreed upon in treaties. After extending perpetual peace and friendship in treaties, U.S. officials often ordered military massacres of tribal nations, purposeful starvation of tribal families, and betrayed legal agreements to maintain boundaries and prohibit white settlers from trespassing through tribal lands. Any act of defense by tribal nations could be claimed as warlike and responded to a genocidal violence. The next area I talk about are phrases using military aggression. Circle the wagons, hold down the fort, off the reservation, and call in the cavalry. I want to just talk about the off the reservation one. U.S. agents controlled food rations in the 1880s, oversaw the abduction of Native children to faraway boarding schools, and enforced the erasure of spirituality and culture through their courts of Indian offenses. This is the context necessary to understand the phrase, if Native peoples living in starvation conditions went off the reservation in search of game or plants to harvest. This was considered an act of hostility and allowed the Native person to be shot by any white person. This is not a funny phrase. It's not a phrase about someone being crazy as we see in popular media. This was a vulnerable position that could lead to death for Native people. Next are phrases misrepresenting Native cultural practices and expressions. Have a powwow, Indian giver, and low man on the totem pole. So I invite you to read the article and read more about where those phrases gain popularity. Words have consequences, particularly when power dynamics are involved. And this article, this talk is about the visually imbalanced terms when the United States is capitalized, but tribal nations are not. Microaggressions, my examples, these often happen in casual conversation, movies, books, etc. And as a tribal person, I have to determine how I will respond. As an educator, I often do try to address it. But the fact of the matter is, in this middle paragraph, for too long, Native peoples have dealt with racism, hate crimes, and constant microaggressions. A study in 2015 found that Native young adults experienced daily microaggressions, 98% by participants, at a higher rate than any other underrepresented groups in the United States. This onslaught of negativity has consequences and is tied to suicide, addiction to substances, and alcohol and other self-harming behaviors. We have to change this language. Indigenous peoples are overcoming the barriers of colonization, demanding change. In spite of the racism and dehumanization aimed at Native peoples, the decolonization of the English language is underway as Native peoples publish their scholarship, write their truth, and uphold the time immemorial sovereignty of tribal nations. Thank you.